There are very few guarantees in life. And if you work in real estate in New York City, there may even be fewer guarantees than you thought. Due to a recent change in the law, you need to examine the commercial guarantees in your contracts, and you need to think about them really carefully before your next deal. My name is Dave Lorenzo. This is Inside Rosenberg and Estis, and today we're talking about commercial guarantees and real estate. And we've got a fantastic person to discuss this topic. My guest today is Alex Estis, and he joined Rosenberg and Estis in 2017. He's a member here at the firm. He's one of the youngest attorneys in the firm's 45-year plus history. He works in commercial litigation. He handles every type of dispute you can imagine. And we're going to talk to him about the changes in commercial guarantees and your next big deal. Alex handles all kinds of commercial litigation disputes, and even if you're doing the transactional side of real estate law, you want to talk to a litigator about this because the litigators are the people who slug it out in court and make sure the laws are durable. We asked Alex to come on the show today to discuss commercial guarantees because a recent change in the law may make your latest guarantee less durable than you thought. So please join me in welcoming Alex to the show. Good afternoon, Alex. How are you today?
I am wonderful, Dave. How are you doing today?
I am absolutely fantastic. So, Alex, we wanted you to come on because we want to talk about changes in the law and commercial guarantees. But I think before we do that, you got to share with us the basics. So let's start right at the bottom. Let's start right at the foundation. What is a commercial guarantee in the context of real estate?
So when you have a landlord and a tenant comes and says, you know what, this is wonderful space, I would love to lease it, this is perfect for my business. The first thing you do is you negotiate a lease, and you negotiate all the typical terms you see, rent, the term, insurance, and then a whole other things depending on the nature of the business and what you're in. One of the things that the landlord looks at is the financial viability of the tenant, and depending on who the tenant is, it could be someone like Starbucks, who is a pretty safe bet that they're going to be able to pay the rent, or it could be Dave Lorenzo, who's starting his new podcasting company out of a ground floor space. Dave Lorenzo is just starting out, so the landlord may require a guarantee in order to secure the performance and obligations of that tenant, or it could be just to secure the monetary obligation. It depends on the situation, and typically it's on a case-by-case basis as to what that guarantee actually holds. But in essence, for purposes of this discussion, a guarantee is a document where someone is going to personally guarantee the obligations of the tenant, whether it's the full performance of the lease or just the monetary obligations.
All right, so Alex, how does a guarantee in commercial real estate differ from a residential guarantee?
Residential guarantees traditionally are not things that you see all that often. Typically, you see a residential guarantor where a residential tenant doesn't qualify to lease the apartment, wherever it may be. Typically, landlord has a criteria. You commonly see you have to have income that's 40 times the rent. But a lot of times there are people that rent apartments that don't meet that criteria. You most commonly see it in college students or people just moving to New York City out of college or anywhere just out of college. And you typically see their parents or a relative guarantee the lease because they don't have a credit history, they don't have money in the bank because they haven't been working, and they aren't able to otherwise qualify for the apartment. So the relative or parent will guarantee the lease. That way the landlord can feel confident that this person who is entering his first job, the parent or relative can guarantee the rent for that residential tenant. But typically in the residential context, it's just the guarantee of rent. You don't see the guarantee of performance because a residential lease is a lot simpler than a commercial lease. And nowadays it's actually really changed because you see a lot of startups entering the field where you have all these companies that are corporate guarantors of residential tenants, or will even pay the rent on behalf of the tenant directly to ensure that the landlord is getting a full year's worth of rent in 12 monthly installments. It's a lot more than that. It's not just guaranteeing monetary obligations, but there's also the faithful performance. A commercial tenant could be just office space, could be ground floor, or it could be an entire building or a triple net lease on a building, which has a lot more obligations, such as maintaining the sidewalk, maintaining the space, having appropriate insurance to guard against any liability, the infinite realm of liability that a landlord could face now and then. It really depends on the context of what it is that that landlord wants to do, but that is what you're looking at with a commercial guarantee. It's a lot more complex than a residential tenant.
So, Alex, you mentioned like Starbucks providing a commercial guarantee. They're not going to have to do it because they're, Fortune 100 company, and their revenue stream is verifiable. They're publicly traded. But somebody like me, who nobody knows from Adam's house cat, I'm going to have to provide a guarantee because the landlord just met me. They don't know. I don't have a history of verifiable revenue. Landlord doesn't know if I'm going to be around tomorrow as far as my business goes. So they're going to want me to personally guarantee the what I'm supposed to do and the money that I'm supposed to pay them. Who do you find typically will provide commercial guarantees, and who would you say almost never provides commercial guarantees, and what falls in the middle?
So it really is a case-by-case scenario. It depends on what type of business you are, where you're located, how much space you're renting, what the term of the lease is, and also, like everything in this world, who are you? That more than anything else. For example, if you're Starbucks, or even the government, because the city of New York, the state of New York, the federal government will occasionally rent space. It's hard to find someone better than the government, really, to be your tenant, to pay you rent, because you almost know the money's there, and it's kind of hard to find someone above that to guarantee it. Starbucks, Apple, for example, two of the biggest businesses in the country, you know they're going to be good for it. I don't see either one of them going out of business anytime soon. And if they are, I think we're really in trouble. But not everyone is the government, Apple, or Starbucks. They could be like you, Dave, or they could be like me, starting to try make their own business, a simple mom and pop pizza shop. The landlord will certainly want a guarantee if the tenant business is relatively new, or it's a new entity being made for purposes of just signing that lease and to operate the business. If there's no credit history, no asset history, they're going to want someone to guarantee it personally. Now, typically, you see it as the owner of the business. That's the person that's going to guarantee it. And what that means for you, Dave, if you were going to do it, is that you personally guarantee the obligations, meaning if the tenant didn't pay rent, for example, you would be liable to pay the rent. Now, typically, like I've said before, it's the owner of the business. But there's also a lot of situations where someone else might step in as the guarantor. You, Dave, could be a 22-year-old coming out of college, and you're trying to start a business, and God bless you, your family's trying to support you. You may not be sufficient to the landlord to guarantee the business. So you may say, hey, mom or dad, or uncle or aunt or friend, can you please help me out and pursue my dream? They may guarantee the lease for you, and in which case, it gets really interesting because that person may not be involved in the business whatsoever. And we'll get into that later about how that affects certain people, but typically it's someone who's involved in the business. I always recommend that whoever's the guarantor for a landlord be someone that's actively involved in the day-to-day operations or oversees the business at a minimum.
So is this negotiable? I mean, is this something that, in your experience, you can, if you're a decent-sized business with 7 years of, let's say, tax returns, you can negotiate with the landlord? Or is it just kind of a matter of fact, you just have to do it unless you're big enough where they trust that you're going to be able to pay them?
It really depends on the needs of the current landlord, because every situation is different. I'm going to sound like a broken record saying that over and over again because it really is on a case-by-case basis. But the things that a landlord needs to look at when this happens is, do you have a lender involved? What are the requirements of the lender? The lender may require that you have a personal guarantee if the tenant doesn't have returns or assets over the value of X or something like that. It also might be the risk preference of the landlord. A lot of times, the tenant entities that operate the business are set up just for the business, or maybe just even in that location to do business, which is why it's a typical requirement that you have a guarantee for your commercial lease. And depending on what the needs are of that landlord, and again, what the terms are, whether it's a short term or a long term, you may want a personal guarantee as opposed to a good guy, or vice versa. Now, there are many different ways to structure a guarantee. When you have a personal guarantee, that's considered a guarantee for the entire term of the lease. And it could be either for guaranteeing the monetary obligations or the full term. And then you have what's called a good guy guarantee. And a good guy guarantee is what you very commonly see a lot in New York City real estate. A good guy guarantee is a guarantor that's either guaranteeing, again, either the monetary obligations or the full performance of all obligations up until a certain point in time. Typically for as long as the tenant is in possession and provided the guarantor meets certain criteria. The name kind of describes what it is. It's for a situation where a tenant is operating its business and the tenant falls on hard times and decides that they can't afford to operate anymore. So what happens is the tenant will send a notice to the landlord, and the notice will be either 30, 60, 90, 120, 150, 180, whatever you negotiate. For purposes of this example, let's say 90 days. I'm going to tell you in 90 days that I'm going to vacate the space. I'm going to give you back the keys. The lease says I have to give it back in broom clean condition. I'm going to make myself current on all the rent up until then, and then I'm going to hand you the keys, sweep up, and I'm just going to be gone. Now, if you follow all the criteria of what your contract provides, you, Dave Lorenzo, as the personal guarantor, would no longer be liable after you give the keys back. The tenant entity itself is still liable for whatever's left under the lease, and the landlord will be fully able to avail itself of any remedies it may have to go after the tenant. But essentially, you know what, Dave, you've been a good guy, you've done everything you're supposed to, so, okay, you're off the hook because you have complied with your lease obligations. Whereas if you have a personal guarantee, even if you gave the keys back, you're still liable under the contract. Now again, a lot of things could happen as to why you may or may not in that situation, and that's a case-by-case basis, and nothing said here is going to be legal advice whatsoever that no one should construe that way. But when you have a personal guarantee, doesn't matter. Whatever the end term of the lease is, whether it's 3 years later, 4 years, 5 years, 10 years, you're personally liable.
So, okay, let's dig in a little bit to that concept, because I've seen something happen, and I wanna understand how this impacts the remainder of your guarantee. So I enter into a 7-year lease, let's say. I'm in year 3 of the lease, and for whatever reason, there's a market downturn, my business fails in year 3. So I do what you said, I clean the place up, I vacate, I give the landlord the keys back, but I'm only 3 years into a 7-year lease, and I got a personal guarantee. So the landlord gets really lucky, and he happens to, within a year, find somebody else to take over that space. So I'm paying because I'm personally guaranteed through year 4, but at the beginning of year 5, somebody rents that space. Am I off the hook for year 5, year 6, and year 7? Or does the landlord get to collect from me and collect from the new tenant as well?
It depends on the term of your contract and what the terms say. Typically, what's common practice is you see a provision what's called a deficiency provision, which is in the event the landlord re-rents the space, even though the landlord at law doesn't typically have a requirement to go out and mitigate its damages. If they re-rent the space and get a new tenant, the tenant would be liable for the deficiency, meaning if your rent was $20,000 a month and I rent it to someone else for $10,000 a month, the tenant is liable for $10,000 a month going forward from the time the new tenant takes possession of the space through what would have otherwise constituted the natural expiration of the end of the term of that lease. Now, you said you have a personal guarantee. If that's a personal guarantee, even though you gave the space back, you as guarantor are liable for whatever that amount would be, the $10,000 plus if there's any arrearages at that point that were covered in between,
Right.
or if there was arrearages before you gave up the lease too. Again, it completely depends on what your lease and your guarantee says.
Yeah.
If you're a good guy and you gave it back and you satisfy all the conditions, which is a big factor. A lot of the cases I see are litigating over whether or not the guarantor met the 3 conditions.
Right. It's my word against yours and how it's defined in the contract.
Well, it's not necessarily my word against yours. It's did you do what you were supposed to? And typically is, did you get all of your property out?
Yeah.
Did you cure all defaults required under the lease, provide your guarantee requires it, and did you pay the rent? The most common thing I see and litigate quite often is, was it left in broom clean condition, and are they still using the space? Those are the things that you typically see.
Yeah, if they're still storing their inventory in there, they haven't really vacated the space, have they?
They really have. You would not believe how many times I've gone to an argument over whether or not are you actually using and occupying the space. But a lot of times, you have to understand, commercial tenants that are giving back the keys, they're giving back the keys because things aren't going well.
Right. So they don't have the funds to move all their stuff out. They're just walking away.
And it's very expensive, depending on, what you have there. If you're an office tenant, it could cost a lot of money to get rid of any of your, desks and other equipment and other improvements you may have made in there. Anyone that tries to leave an apartment in New York City knows what a hassle it is.
Yep.
And will usually post on Facebook, hey, who wants this couch? I have to get rid of this.
Yep, exactly.
It's
right.
really not
just come get it. Just come take it.
Right, exactly. In the commercial context, it's a lot harder than to find someone that wants your couch.
Yeah.
And that's if you're an office tenant to get desks and other things. If you're, for example, a restaurant, you may have a lot of cooking equipment, which may not be fixtures, but also might be leased from other companies. And they may just want to get out before the company they lease from is able to pick up their equipment. And then it becomes a big issue with the landlord in terms of getting rid of that, because we also might want to re-rent the space.
Yeah.
And we have all this equipment in there, and we're probably going to want to do a build-out for whoever the new tenant is, or the tenant may want to do a build-out. It becomes a very big deal. It's not as simple as, well, how come you can't get your stuff out of there?
Yeah.
It comes up more often than you think.
So let's go on the flip side, because this is something that I have personal experience with. Your business takes off, and the space that you're in, you've outgrown it, right? And in my experience, this is where great communication with the landlord always pays off, because you've outgrown the space. The first thing I would do is go to the landlord and say, listen, what else have you got for me? I need bigger space. I need more space. You got anything else in this building? And then the landlord will work with you. Worst case, can you go to the landlord and say, look, I outgrew your space. I asked you, you don't have anything else for me. I've got a subsidiary business. I want them to pick up the terms of this lease. I want them to sublease from me. Can we work that into it somehow? Given the current state of the market, are landlords open to that kind of thing? And I know it depends, but based on your experience, like you go to the landlord and you say, I want to do the right thing here. I want, I'm still responsible for the rent. I want to put somebody else in there. I'll pay you and I'll collect from them. What's your experience recently with this? Is this a possibility?
Well, again, it depends, and depends on the terms of that contract. But as a matter of practice, whether you're a tenant or a landlord, I always encourage people to try and talk it out. Because, people talk a lot about how there's a lot of animosity towards landlords, and, they get a bad rap a lot based on how people look at them as these corporations that don't want to help you, and these billion-dollar conglomerates that just look at their bottom line. But not all landlords are like that, and landlords can be people too. Tenants are people too. Businesses, corporations are people too.
Well, and vacancy costs everybody money. So the less vacancy they have, the happier they're going to be. So give it a shot.
Right, and honestly, when you sign a lease, it's a partnership. A successful tenant makes a successful landlord, and vice versa. A successful landlord that has a wonderful space, a wonderful building that's run well, creates an opportunity for a tenant to operate their business in a location that could help increase their revenue. It's a symbiotic relationship. Everybody wants everyone to succeed, and when one doesn't succeed, it hurts the other. If the landlord's struggling and can't make repairs, it hurts the tenant's business. If the tenant's business is hurt and their revenue is hurt, it impacts their ability to make money. Their impacted ability to make money impacts the landlord's ability to collect rent. It doesn't help anyone to fight with the other. It's always in the best interest to try and work together and come to a good solution. Now, things happen, and like in any relationship, people have disagreements and they can get heated, and sometimes you may have to fight about it, but it's always in everyone's best interest to try and work together and to create the best possible result for both parties, because everyone benefits.
All right, so Alex, you and I were talking before the show. We were talking a couple of weeks ago, and you were telling me about changes in the law related to guarantees, and it's really important that we share these with the folks who are listening, with the folks who are watching. So, what's changed recently, and how is it going to impact first the landlords, and then how is it going to impact the people that they're leasing to?
Well, the law is a fluid thing. It's constantly changing, and especially in New York over the last few years, going back to 2019 when you had the HSTPA invoked, and as recently as 2 months ago with the enactment of good cause eviction, New York State has been changing the law a lot in terms of how it affects property owners in New York City and New York State. There was a recent First Department Appellate Division case decision entitled Archives LLC v. Volpe, which I think should be on everyone's radar because it's going to change the way we write guarantees. In that case, you had a tenant that was holding over past the expiration of the lease. And there was a personal guarantor, and the guarantee had the following language. The guarantor absolutely, irrevocably, and unconditionally guarantees all sums due and owing under this lease. And that's very common to see in a lot of leases. I've seen that more than I see my own family. It's that common. And what that means is absolutely, irrevocably, unconditionally, you have no real defense, and that it's not conditioned on anything, and it's nothing the landlord has to do, but you're absolutely guaranteeing that you are going to make sure the tenant pays. If the tenant doesn't pay, you're going to do it. Guarantees, a little step further, may have an actual clause that says that they waive all defenses, and that if the landlord sues, the guarantor has no defense, which that's another thing. But typically that sentence is used absolutely, irrevocably, and unconditionally, all sums due and owing under this lease. The historical context is if the tenant owes something, the guarantor will be liable for it. What this case, Archives LLC v. Volpe, said was that it has to be stated in the terms of holdover, use, and occupancy. What's a common principle in leases is that if the tenant's lease is terminated, or the lease term naturally expires when it does, and the tenant doesn't vacate it, there's usually an agreed upon rate for holdover, use, and occupancy. Some leases don't have it, some leases have a liquidated damages, some leases has an acceleration, but most commercial leases provide that there is a higher number than the rent that the tenant owes the landlord if they hold over. The purpose of that, of course, is the landlord needs to be secured in case the tenant fails to vacate. The landlord needs to make sure that they are compensated for that, for any additional expenses that may arise, and also as a deterrent to make sure that the tenant leaves when they're supposed to. In Archives LLC v. Volpe, the First Department found that holdover, use, and occupancy is not something the guarantor is liable for, even if the guarantee may say they guarantee all sums due and owing under this lease. It has to be expressly contemplated, is what the Appellate Division said, and that the First Department, at any guarantees written, should say what the guarantor is going to be liable for. So, you see a lot of guarantees say fixed rent, additional rent, and other sums due. A better practice would be that they guarantee fixed rent, additional rent, holdover, use, and occupancy. If there's any other monies that are due, it's better practice to expressly say what it is the guarantee is guaranteeing, and then maybe you say all other sums.
So basically, because of this case, you're telling folks they have to be way more specific in their guarantee language, right? So holdover needs to be specifically addressed.
It's a very big deal, and it should be addressed because a lot of landlords think they have guarantees that cover fixed rent, additional rent, and holdover. Their guarantees are not the guarantees they thought they may have, and going forward, it may need to be updated. And I'm seeing a lot of guarantees that have actually been drafted subsequent to this decision coming out that don't account for that. And that's also, another point I tell clients when we're negotiating these guarantees is you should always have a litigator present in your lease negotiations and your guarantee negotiations, because we think a little differently than transactional attorneys. Transactional attorneys have their skill set, which are skills I absolutely do not have as a litigator, and vice versa. But if you have someone that has a guarantee and there's changes in court decisions, you always want your litigator to look at the guarantee, to also look at how I would litigate it. I would look at the language and see, how would I think a judge is going to act on this? What have I seen from my own experience, which might be different than a transactional attorney? You definitely need both, or someone that does both. But in the context of this decision, I think it's a huge change for the industry, and it's something that we need to account for, because if you have a guarantee that doesn't have the protection of guaranteeing holdover use and occupancy, it's one less deterrent for the tenant to leave when they're supposed to. Now, I say that because if it's a good guy guarantee we're talking about here, or even a personal guarantor, if they stay past the expiration, the liability is kind of capped at whatever the fixed rent is, and from the moment after termination, the guarantor may or may not be liable. Now again, that in a good guy context, we can get into a fight about whether or not they satisfied the surrendering of the broom clean condition, or other conditions that might be specific to that guarantee. But if it's just a tenant holding over for holdover use and occupancy, the guarantor may look at it as, you know what, I can stay here and continue to do business, and I don't really have to worry about paying the landlord because I'm not going to be on the hook for it.
Yeah.
There are some people that may try and take advantage of that situation. I think most people doing business, I like to think, are good people. It's something that needs to be taken into account of. And also, there's protection to the guarantor himself too in having these things done, because whether or not you're liable for something doesn't mean you're not going to have an expensive lawsuit at the end of the day.
Right.
So these types of things are going to, I think, create headaches for both sides, because this case can be overturned any day by the Court of Appeals or a subsequent decision. We're not exactly sure. If you're a guarantor, I want my obligations to be very clear so I can act accordingly, because even though I know I'm in the right, I'm not liable for this, there could still be a very long litigation that takes a lot of time, a lot of money, and litigation for a lot of people, could really eat your kishkas out and create like a real personal strain on your life. So there is a benefit to everyone about making sure your contract is clear and that you know what you're guaranteeing and what you're not, and so everyone's on the same page.
Yeah, I had a friend and a client who was a fantastic litigator, and what he tells all of his clients when they first step into his office is litigation is not designed to be easy, it's not designed to be cheap, and it's not designed to be fair. Litigation exists as an encouragement for people to work out their differences. That's why there's litigation. So the more specific, and the point that you made about having litigators review contracts. So if you're a non-lawyer and you're watching this and you're listening to this, let me break it down like a fraction for you from another non-lawyer, from a business guy, right? Transactional attorneys are fantastic. We all have them, and we all work with them. Their job is made easier by them doing similar things, writing similar contracts over and over and over again. So they start with a shell of a document, and then they modify it to fit your needs. They keep up with changes, as Alex said, in the legislature. So new laws are passed, they get an update, they read it, they study it, they modify the shell of the document based on what the legislature does. The transactional attorneys don't necessarily keep up with the case that ended yesterday that destroyed one section of the law. Well, candidly, if it destroyed one section of the law, they'd be up on it. But if it makes a little tweak, if it makes a little change to the law, if it's a nuance in the way a paragraph of your shell of a document is interpreted, the litigators are going to know that because it's their job to find that needle in the haystack or that thread and pull on it until the whole thing unravels. It's the transactional attorney's job to get the documents together so the deal can get done. It's the litigator's job to unravel that document. So it makes perfect sense for you to work with a firm that's going to draft your documents and then for you to say, hey, Joe, do me a favor, walk down the hall and get Alex to read this. It's going to take him probably 3 or 4 hours. We'll pay for 3 or 4 hours of his time. Let him read it and let him make some notes as to where he would pick it apart so that we could strengthen it. That point that Alex made about this change in the law and how it impacts your guarantees just highlights that fact. I tell my folks who are doing deals all the time, the business owners who are doing deals all the time, 2 types of lawyers you want looking at the documents the first time you use them. After the transactional attorney goes through the first draft, you want a litigator to look at it. You also want a bankruptcy attorney to look at it. Because if something happens and if you go into bankruptcy, or you're signing a lease and the landlord goes into bankruptcy, you want to know how that impacts you. The first time somebody's drafting documents from you, and anytime there's a change in the law or years pass by, you always want a litigator to look at those transactional documents. So, Alex, in the time we have left, I want you to explain to the business folks, because now we just took the attorneys to school, right? All your friends in the firm who are transactional attorneys are going to go, yeah, thanks a lot, Alex. Now everybody's going to ask for you to review their documents. Okay, so now let's talk to the business owners, Alex. So I'm a landlord. If I have a really good guarantee, does that increase the value of the property if all my tenants have really good guarantees?
Well, the value of the property, I think, more depends on what the leases are as opposed to the guarantees. It's really a question of, are you getting good rents? Are you generating good revenue? Are they anchor tenants? And when I say anchor tenants, I'm talking about that blue chip tenant like Starbucks or Apple or something like that, where you're getting above market rents. That's what investors are going to look at, and that's what lenders are going to look at when they're looking to assess a value to your building, how much revenue it's generating. The terms of the lease themselves do factor into it and the enforceability, but I think more than anything it's what the revenue is. Because the really interesting thing about guarantees, and I would say this is the biggest misconception in real estate about L&T, is that the guarantor's liability and the tenant's liability are not always one and the same. In fact, again, it depends on the terms of your lease and your guarantee, but more often than not, the guarantor's liability is broader than that of the tenant. There are a lot of guarantees that have provisions that call for a waiver of defenses. Now, what that means is that if the landlord sues the guarantor for the rent, the contract says that the guarantor has no defense to non-payment of rent. Sometimes there's exceptions. Commonly you see the only defense the guarantor can raise was the debt was paid, which is a very fair provision. But a lot of times the guarantor's liability is broader because you're, again, using those 3 magic words, absolutely, irrevocably, and unconditionally guarantee the money. And it makes enforcement a lot easier because guarantee cases could sometimes be a lot quicker than suing a tenant over what they owe, because that could have a lot of different defenses. That could be a lot of factual issues. A guarantee litigation is very simple. How much do they owe? Did he pay? Yes or no? It could be a lot quicker. Now, again, it's on a case-by-case basis. It depends on the facts of that situation. Depends on the contract. So it's not like it's a general rule of thumb. But lenders and investors, savvy lenders and investors, when they look at the value of a property, I think understand that if you have a standard guarantee, the enforceability should be good. It's just more of a question of who is the guarantor and how viable is he as someone to guarantee either the full performance of the lease or just the monetary obligations. That becomes a whole nother discussion in terms of what people look at. And a lot of landlords, unfortunately, don't even know if the guarantors are viable until they're locked in litigation and see that they may not be able to get anywhere.
Yeah. All right, Alex, if people want to reach out to you to have you look at their contracts, or if they have a challenge with a guarantee, if they're a landlord, if they're a tenant, how can they reach you?
They could reach me by email at Estis@rosenbergestis.com, or call me in the office, 212-551-1204. But I also want to say that this firm, Rosenberg and Estis, is truly special in that we are a one-stop shop for everything. There's a lot I can do, sure, but there's even more that the people here can do, and there's wonderful people here, incredibly brilliant and talented attorneys in our transactional department who can do a lot of things that I probably couldn't even understand. They're absolutely fantastic. And what you were saying before, Dave, about how you want a litigator and transactional attorney, whether it's me or somebody else here, you want someone from both worlds to do it because we both have different perspectives. In the end, it's giving more protection to you, the client. And whether there might be another issue, tax or administrative, odds are we probably have someone here that has dealt with it. It really doesn't hurt. And trust me, in life, there are so few guarantees. You really want to make sure that your commercial guarantee is one of those surefire things.
All right, thank you, Alex. Once again, if you want to reach out to Alex, you can call him at this number.
212-551-1204, or you can reach our firm on the main line, 212-867-6000. You can either see me or one of my many incredibly brilliant and talented colleagues.
All right, thank you, Alex Estis. It was wonderful to have you with us today. This has been Inside Rosenberg and Estis. I'm Dave Lorenzo. We'll see you back here again next time.